Right, so welcome. This is the second in this semester's series, GDI lecture series. Really pleased that it's been given by one of our leading colleagues, Professor Bina Agarwal, on the issue of do courts grant women, Indian women, their inheritance claims. Bina sort of needs no introduction, but it's always good to remind people who have not known Bina for as long as some of us have, of where she comes from, what she's achieved in her career. So she's with GDI, but associated, as you can see, with the Institute for Economic Growth in Delhi. It's a good association to keep, lovely officers. Bina hosted us for a wonderful workshop many years ago now, probably 10 at least. 10 years?
Yes.
Yeah, so quite some time ago. But definitely, I'm glad we've still got that link there. Bina's work is across agriculture, environmental change, property rights and law, but the key thing is she approaches this from a gender and political economy perspective, and that's where her award-winning work has come from. The award-winning books, Field of One's Own, Gender in Green Governance in 2010, and then in 2016 a real sort of honour for Bina's work to be pulled together in 3 compendiums and issued by Oxford University Press. I'm not going to go through all the prizes because there's quite frankly too many, but the one that I know Bina's particularly pleased of is that she was the winner of the first Global Inequality Research Award to be received next month, in France. So very proud to have this association. I was pleased with Anifat to be teaching a class with Bina on these issues to some of our students who are here today on Bina's Gender Inequality course. I always learn a lot from the experience. So very pleased to be chairing this session. And Bina's going to talk for about 45 minutes, and then we'll open up for question and answers. So, over to you, Bina.
Wonderful. So thank you, Sam, for those warm words. And thanks for GDI for organizing this lecture, and particularly Louisa and Kata. You've put in so much background work. You know, we never imagine how much work goes in for every lecture. So thank you very much. So this is a co-authored paper with Shruthi Naik, who qualified from the Bangalore School of Law. And it analyzes case law which was obtained from online sources with meticulous support from 3 law interns who worked for 2.5 years on it. So it's a quite laborious work. I believe it's the first paper which examines gender bias in courts across India over 15 years and for all states. Now what we know is that the issue of economic inequality, whether you measure it in terms of wealth or income, has had a very long history in development discourse and research, going back at least to the 1960s. And I'm sure many of you can reel off some of these names: Tony Atkinson, Amartya Sen, Stiglitz, Milanovic, Piketty. 2 of them are Nobel laureates. And Piketty in particular underlines the role of inheritance in the perpetuation of inequality across generations. However, none of them have specially focused on gender inequality in property ownership. I did so in my 1994 book, A Field of One's Own, but data at that time wasn't a topic that people were working on. Data on it was quite sparse. More generally, we find that neither economists measuring economic inequality nor legal experts normally examine legal data empirically. So my talk today is based on recent work which is on the interface in a way between economics and law, and it focuses on gender biases in courts and empirical analysis, which is based on this legal database, as I said, over 1.5 decades in the context of India. But before I go into the details of that, let me give you a little bit of the history of legal reform in India. Now, India's actually had a very long history. In the 1930s, there were newly formed national women's organizations in undivided India, which was then under British colonial rule. India became independent in 1947. And at that point, in the pre-independence period, these women's organizations, some of them going back, as you can see, 1917, they raised the issue of property as a key demand partly for its own sake, but also because it was linked to the right to vote. And that was not unusual. I think even in the UK you found that, you know, the whole discussion was whether you had the right to vote, had property or not. And basically at that point in time, there was a cross-cutting across religious groups of these groups. They were not particularly either Hindu or Muslim. Everybody was involved. So across religious lines, these groups formed committees. They studied the law. They spoke to lawyers. They published pamphlets about women's position. And they encouraged legislation to enhance women's status. Now, one of the results of this mobilization was the Hindu Code Bill in 1942. And there were progressive liberal male lawyers who were also interested in reform, who were supportive. Now, what this Hindu Code Bill did was that it focused on sought to enhance the daughter's rights in inheritance. And so here you see this discussion started in the pre-independence period, but then bill was tabled, and there was a huge discussion around it, both in the Constituent Assembly in particular, and you find that around 1948, and there were parliamentary debates subsequently. And as you can imagine, there were mixed responses from male legislators. Now, some argued that giving women shares to daughters, they would say, would spell nothing but disaster. But others, such as Ambedkar and Nehru, these two pictures, they were the liberals, and they felt that this should be taken forward and legislation should be passed. And as you can see, newspapers carried cartoons, and they had quite a field day to this. So you can see that one cartoon, which is published in National Herald, that is Ambedkar, and this is the villager standing up and saying, "Get out. No way will I give daughters." And I'll give you another example of that cartoons at that time. People demanding that they should be given a dowry, and you can read it and you can see the kinds of responses. But these were not just caricatured responses. In fact, there were delays on the passing of this. There was opposition within the Congress party itself, and it was then postponed till the first elections were held. And when Congress came into power, then the Hindu Code Bill, which had 4 different elements to it, there was property, there was right to adoption, marriage, and so on, was passed in 4 separate acts. And the one relating to property was the Hindu Succession Act of 1956. Now, although this was still gender unequal, it shifted the women's rights to property from a position of gross inequality to a fair degree of equality for some more than 80% of Indian women who were Hindu, and then plus a few of other religions. So the question is, what was this shift? So overall, I think what we need to keep in mind is that the inheritance systems in South Asia, and that, my work actually covered all of South Asia. It covered 5 countries: Pakistan, Bangladesh, Nepal, India, and Sri Lanka, are extremely complex because they differ not just by religion, they also differ by region and then type of property. So landed property is treated differently from other types of property. Now, most Hindus actually fall under the purview of the 12th century Mitaksha law, which makes two distinctions between separate property and joint family property. Separate property is self-acquired property, and joint family property, you can say, is some kind of ancestral property in which people have a right to by birth, and they are called co-partners. So, for instance, if you take Amartya Sen, his Nobel Prize money would be his separate property, but his house in Shantiniketan will be ancestral property, as an example. Now, prior to the 1956 Act, the vast majority of Hindu women could only inherit the father's or the husband's property in the absence of 4 generations of men. And if they were absent, then the first right was the widow's, then the unmarried daughter, and then the married daughter. This is important to remember to what I'm going to say later. Now, the 56th Act gave widows and daughters equal shares with sons in a man's separate property, interstate if there was no will. But two kinds of inequalities remained. First, daughters could not be co-partners in joint family property, so they had no rights by birth, unlike sons. And agricultural land was treated differently. So agricultural land was subject to state-level tenurial laws, land reform laws. So each state had a different law. And in 6 states, this tenurial laws actually specified an order of inheritance, which was highly gender unequal and which was similar to the 12th century Mitaksha system. So now you see, and land reform was of course seen as a great, it was very important across the globe in that period. It was carried out, and then what the Indian Constitution did is that it put it in one of the schedules of the Indian Constitution, which could not be challenged on grounds that there was on constitutional grounds. They wanted to protect it from landowners from challenging it because the right to property was enshrined in the Constitution. But it also meant that it embedded in gender unequal laws which could not be challenged on constitutional grounds, although the Constitution promised equality, no discrimination on the basis of sex and caste and so on. Now, despite this, the trajectory of legal reform continued. So 5 states, notably all in the south and west, amended the Hindu Succession Act of 56 by Kerala abolished joint family property altogether. Some of you will know that Kerala has about 35% or historically had naturally male population. But the other 4 states, what they did was, you could allow unmarried daughters to be co-partners in joint family property. And these are the states in the map you can see are colored. Now, subsequent to that, the other major amendment happened in 2005. It was part of a civil society campaign that I actually led. And at that point, the remaining inequalities in Hindu inheritance were overcome. In 2005, their joint family property, co-partners could be both married and unmarried daughters, and the discriminatory clause on agricultural land was removed. So after 2005, what you find is that at least for Hindus, which is Hindus plus Sikhs, Buddhists and so on, 83% roughly of India's female population, women have equal rights with men. So what was this big legal change between 56 and 2005? So to give you a better idea, so I've mentioned this here, but then I will give you some diagrams. So if you look at this diagram, and take a grandfather who has 90 acres of land, and he has 2 sons, S1 and S2. S1 has a wife and son and daughter, and S2 doesn't have wife and kids. So the 90 acres is shared between the man, the grandfather, and the 2 sons per stir piece, which is there are 30 with the man, 30 with the person who has no family, and also 30 with S1. However, since S1 has a son, he shares it 15-15 with his son. So it's every step. So if for instance SS1 had a son, then he would share it equally with his son, 7.5 and so on. So this is the way it was structured. And as you can see from here, and I'm only focusing on the joint family property because in the separate property, sons and daughters had equal claims. So here what you see is, S1 is, let's focus on S1. So if S1 dies, his son, SS1, will get 15, which is his direct right in the co-partnery, and 5, which is his share, in equal share in his father's co-partnery. The daughter gets and widow only get 5 each in the father's share of the co-partner. And it's highly unequal. So this was what it was in 56. Now in 2005, what happens is daughters also become co-partners. So you have the same family, but what you see is that S1, his 30, are now shared not only with his son but also his daughter, so it becomes 10 each. The right of then his share 10, if he dies, is divided equally among the three. Wife, widow, son and daughter. So you see that the daughter and son have equal shares, 13.33 acres of land. The widow goes down. She has 3.33. Now this is really interesting, because one of the things that happens when you look at legal discourse and you have campaigns to change gender inequality, that people tend to forget that there can be intra-gender inequality that can arise. But that's really typically not taken into account. Now, having said that, of course we know that equality as an idea is embodied not just in the laws, but also in the institutions and practices of everyday life. So where were we in practice after a century of effort? The question is, have we bridged the gap between de jure and de facto rights, and has actual practice kept pace with legal reform? Now this answer is extremely important, because we know that actual ownership of immovable property like land has very important welfare and efficiency implications. And there's a whole body of work which has grown up globally on it, and I'll just share that with you. So when A Field of One's Own came out, I had structured it in terms of its welfare, efficiency, empowerment effects, and at that point culled together whatever evidence there was. But since then, there's huge amount of global evidence from Latin America, from Africa, which shows that when the mother owns assets, it has much greater effect on child survival, health and education than if the father owns assets. So it's not just about children growing up in a well-off family. It matters who within the family actually owns it. And one important reason is that there is again a lot of evidence to show that women tend to use their assets and their incomes much more for the children's needs than the father does. And then I had done a subsequent paper long after this, which came out much later in two journals. One is World Development, one is Journal of Human Development, in which we looked at for the first time whether it made a difference to domestic violence. Now there's a huge body of work on domestic violence which basically looks at a range of factors, and to the extent they look at economic factors, it's about women's employment. But in fact, the moment you put in property, what I found, and I won't go into details here, is that, and this was 500 randomly selected households in Kerala, which is a women's friendly state. So where you had completely property-less women, the incidence of physical domestic violence was 49%. When they had house and land, it was 7%. And then it was in between 10 and 17. And they'd be controlled for everything else. And the interesting thing was that if they had casual employment, not formal employment, they were actually subject to greater violence. Or if they were better employed than the man, but if they had property and the man had no property, they still were protected from domestic violence. And this, I just want to raise this, that in a multi-sense capability approach, you typically look at absolute capabilities, but what this showed, and some other work subsequently on other counts, shows that relative capabilities also count, and it's not just absolute capabilities. There's then the question of efficiency becomes that if you're talking about agricultural land in particular, then it's important to see what impact that has. And there's been, again, a lot of work on this, especially on Africa. But FAO in 2011 put together 24 of these studies. And in their assessment, based on that, they argued that in developing countries, if women had the same access to land as men to inputs in farming families, their yields would be 20 to 30% higher, and the agricultural growth rate would be 2.4 to 3%, and hunger would decline. Now this is important because increasingly what you have is a feminization of agriculture across the developing countries in the global south, where more men than women move out of agriculture and women tend to be left behind. And it's also important if you look at SDG 5, which is where there is a target for gender and land in that, and also SDGs 1 and 2 on poverty and hunger. So it is pretty important that not just in law, but also in practice, that women should own assets, especially land. So what's the situation in practice? Now here comes the crunch that relevant data to get was extremely difficult because most agricultural censuses and national surveys don't gender disaggregate data. They have it at the household level, or you don't provide that. Even digitized land records which are happening don't give you gender data on that. But there is new data more recently, and here's some figures that you can see based on a range of studies. So it's not just Asia. You take 4 countries, Nepal and Bangladesh, India, and so on, and you see that 14 to 37% women landowners as a percent of all landowners. In Africa, Cheryl Doss has done work for 10 countries, she and a team of people, other scholars, and the average is 22%. Latin America, you would imagine it would be more egalitarian, but it's not, 11 to 27%. The range is according to which country you're looking at. And then there's some attempt to work on UK, less unequal in overall so-called wealth, but pension incomes are hugely unequal. Of course, linked to labor market issues. So overall, we know that women are less likely than men to own land. And the most recent 2024 UN snapshot report, which just was shared with me last month, that women were much more likely than men to own land in 40 out of 46 countries with data. So given how many countries there are in the world, this is a minuscule number for which we have information. But it's a good question to ask. What about Germany? What about Europe? What about the United States? And I think you'll have some answers. Now, in the context of India, as you'll see, only 11.6% of households have any female landowners. Very small percentage, after all the equality in law. And interestingly, I marked it in red, there is a very important regional difference. So to the extent that you have better figures, you'll find that all those states are in South India, Karnataka, Andhra, Telangana, Kerala. But even Kerala, which is supposed to be a certain one, at least 1/3 matrilineal, does not do over the top well. It's 28. But the worst is, of course, North and East India. Then I did more granular work on this because, you can measure inequality in a variety of ways. And you would also want to know, well, of all landowners, how much are female, how much land is owned by women. And so this was a paper in the Journal of Development Studies, which came out in 2021. Only 14% this is across 9 states in 2014. Only 14% of all landowners were female. Women owned only 11% of the land. And this is the most important part, most of them were older widows. Now what this means is that if you're older widows, then all the kinds of advantages are listed in a previous slide. That if women have young children, they'll survive better, they'll do better in education and health. It's not an outcome that's going to happen because it's too late in the life cycle for that advantage to occur. Okay. So then this I've already talked to you about this. The question is, okay, their families are not willing to give them landed property in inheritance. So do they go to court? Well, as you can imagine, many women actually just forfeit their shares. for a range of reasons. They have to sign an affidavit in order to do that, or they seek out-of-court settlement. Why? Because it's very expensive to go to court. So there was a study done by a legal think tank, and it interviewed 9,300 litigants across 24 states, and it found that the average litigant earning 1 lakh, which is about 1,000 household income per year, spend 25% of this just attending court hearings. So you have to pay the lawyer, you have to travel because courts are concentrated in urban contexts, and so on. And then, although it is true that poor women, scheduled tribe, scheduled caste, and poor women can get legal aid, very few use it. And only 2.7% used court-appointed lawyers. So there's a system by which you can have lawyers appointed by the court, but people usually don't even know about it. And then if you go to court, it's very time-consuming, it's long distances for hearings, you lose your work and income. So law is also very complex. I mean, as I just showed you that in that slide, it's extremely complex. And then there are social costs. The social costs are very important because it erodes family relationships. So if a sister, or if say a daughter disputes that her brother is not going to take all of daddy's property and I have a right to it, then the typical result is that the relationship breaks down. Mm-hmm. So women make what Dennis Candioti has called the patriarchal bargain, which is, it's a deal which is okay, I'm going to give up my claims. And of course an underlying story in that is, of policy is that because you have no social security to fall back on. It was very interesting that when I was doing a field work and so on, I came across quite a lot of ethnography where in Bangladesh, women said we will claim our rights because anyway they were not going to be supported by the brother. And because they were working in groups, many of these were interconnected to BRAC, they said, well, the Samiti is our brother. So the point of it is that if you have alternative systems to fall back on, you may be more compelled or more encouraged to actually go to court. So how many seek? So what they do is they have out-of-court settlement. This is something in between giving up your claims and going to court. And this is another survey that the same legal research group did, and they found that only 32% of them, about 32% resolve their cases informally outside the court. So typically you negotiate with the other party either through friends or relatives or through the village council. And women, not surprisingly, sought mediation more than men. 1/3 of property disputes were settled out of court. But some women did go to court. And what is interesting is in the 2005 amendment, because married daughters could also claim co-partnership rights in joint family property, their husbands and their sons and the male members of their family were also interested in obviously in supporting this. And it was very interesting because I was involved in the amendment of the 2005 Act. So after that, the newspaper had asked me to write what had happened, so I did. And I started getting these emails saying, Professor Agarwal, always from the men, saying, my mother has this ancestry property, and a lawyer is saying she doesn't have a claim. What do you think? So I would say, look, I'm not a lawyer, but I'll interpret it for you, and I did. In 2 cases, they actually did win the case. But in other cases, the lawyer had been right because it's such a complex system. But anyway, what I'm saying is that there are interested parties beyond the woman herself. So then we have a range of questions in this paper. Are there regional variations in case filing? For instance, there's the South more than the North. Who are the opposing parties? What kinds of properties are disputed? How much time does it take to settle disputes? And of course, what are the outcomes? And then we went a step further and we said, let's also look at the language of judgments used by the courts and by the councils. And then we always want some policy-oriented outcomes. I mean, that's been a lot of my research trajectory, and therefore, are there ways forward? So the study that we did looks at both women as claimant, both as those filing cases and as well as those as defendants when cases are filed against them. This is a very broad structure of the Indian courts. So you have the Supreme Court, the High Court, and below that is a range of what are called trial courts. Now typically cases come to High Court after they've been through the trial court, but in some cases, depending on the amount of value of the dispute, the amount that's being disputed, then you can also write directly to the High Court. And only 5 High Courts out of 25 do that. So we used 4 online databases. The first is and we analyzed for 15 years from 1st October 2005 after the Hindu Succession Amendment Act was passed till December 2020 relating to Section 6 of HSA. I'll explain in a minute what Section 6 is. And this is not like a database you'll just log in and you'll have all the figures. It's not like that. You have to actually download each case. So we used as a tagline Section 6. And dozens of cases came up. So, and out of that only some were relevant to our research. So, and then you have to read through that in order to answer any of those questions that I had posed. You have to read and interpret it. It's not just out there. So Supreme Court online data cases, we examined first, and then we went to what is called the e-courts cases. And there we found, what we did was, there are some overlaps between the two, so we check that there are no overlaps when we go to the second database. And then we take only which have not been covered by SCC. And then there's a third one, India Qanun, and then there's a Manupatra. Some of these are perfectly open access, and some of these you have to pay for, or there's some kind of wall. But if you pursue, you can get it. So to the 2939 cases that we came into our basket, we found that 505 were relevant. And these are High Court cases which have been resolved because we're also interested in the outcomes. By the way, we also did one other thing. India has this Right to Information Act. So we thought, although we've been assured by legal experts that this will cover, at the High Court level, will comprehensively cover the cases, nevertheless, we filed these right to information and sent it to all the High Courts, saying how many cases do you have, just simple questions. But the information we got back was so fragmented and it was quite different from what we gathered, so we decided that it wasn't a good cross-check. But we did do that, which is typically people don't bother to do. That's the cross-check. So Section 6, you don't have to read all of this, but I've highlighted some parts which are important. Section 6 relates to where the property, the daughter is a co-partner, and by birth becomes a co-partner in her own right, in the same manner as her son, and she can dispose of the property as she wants by testamentary disposition, and the share she's allotted is the same share as the son. So these were the cases that are filed by women, cases that are defended by women, and here you can see that there is a north-south interesting difference. So most of the cases, High Court cases, the opposing parties we found were the brother, either on his own and also sometimes supported by his mother and or parents. We found in 72% of the cases defended by women, 62% of those that where she had filed the case, the opposing party was the family. And this is interesting because you might say, well, why is the mother supporting him? But again, it's part of this whole patriarchal bargain. There's a lot of feminist literature on this, that women have to, if they have no other option, then they depend on the male members of the family for livelihoods. The interesting thing is 64% of all cases relate to South India. Just keep it in mind. So what type of property is disputed? Now this took quite a lot of granular thing, but a lot of it is rural property, accounts for 80% of the cases that women file. and 61% where women are defendants. You would imagine that it would be more urban, but of course, in a way, when you think about it, agricultural land is held much more in common than, than urban houses and so on. What was also interesting was most cases were on agricultural land, and the amounts that were disputed were actually quite small. So about 50% were less than 5 acres or 2 hectares. So as you can see, we've done it, but some of them are quite even less than that. So you'll say, well, why are you disputing for such periods of time such small amount of land? But then it begins to make sense, because actually 86% of farming households cultivate less than 2 hectares in any case. I was surprised by this because I had really expected that it would be larger estates that would be disputed. Okay. Yes.
Do you have any information like how many siblings they had, like when they were filing the case?
No, because the case law doesn't actually tell you. All you'll know is how many siblings joined with the defendant, or the other person. So there were cases where there were 3 sisters who came together and they were being opposed by the brothers. You can have anecdotal nuggets which you can pull out, but you can't actually have a full picture, because that information is not provided in the case law. So what is the outcome? Now this is both, it's a mixed picture. So what is the good news? The good news is that women were granted a share in some form of property as a result of this litigation in 77% of the cases. But the bad news is that only 52% of these, about only half of these positive outcomes, were women being granted a direct share in the father's co-partnership. In other cases, they were granted a share, so the father's co-partnership, the right to the father's co-partnership they already had in 1956. So these disputes are happening after 2005. But in half the cases, the outcomes are such that what they are being given is only a share in the father's co-partnership. Do you get what I'm saying? That the women could claim after 2005 2 types of rights in joint family. One was the father's share in the ancestral property, in which everybody had an equal right, sons and daughters. The other was their right to birth, by birth. So they were fighting for the right by birth, but what they were granted was a share in the father's co-partnership.
It's a much smaller amount, right? I mean,
well, apart from smaller, it was a right they already had in 56.
Right.
They were not being granted this on the basis of the amendment in 2005. And remember, these cases we've looked at till 2020. But even in these 52% of the cases where women as unmarried daughters were granted co-partnership, it was really, you find that if you look at the state level, it was in many cases the states which had done the amendment even much prior to 2005. So basically what I'm saying is that in most cases the daughters were granted shares on the basis of rights they had earlier and not the rights that had led to a gender equal law. And that women had to file cases to get these shares even some 68 years after the law was enacted, from 56, indicates that the daughters' claims continue to have low social legitimacy. And then the regional variation is also striking. So 68% of these cases where women were granted any type of property came from South India, as did most of the cases where they were granted co-partnership rights. Now, of course, you can say that these figures are partly reflect that more cases are filed in South India. So what we did was, let us look at the success rate, which is of the cases filed, what proportions are successful. And again, we find they're much more successful in the case of South India, 76% so of all property. It's 90% in the case of South India. Of the cases filed, they were successful. And you know, the thing is that even historically, I mean, we have evidence that it was South and West India where the women's rights were much more granted. And we didn't have enough of a sample to look at female judges versus male judges, but only 15% of them were by female judges, but there was no obvious gender advantage of having a female judge. In fact, sometimes on the contrary. So why is there resistance to daughters inheriting, and are there regional differences? So an important factor is social norms. Now social norms is being much touted by economists who are talking about it. That's now become like social capital, you know, everything that you can't explain is because of social norms. But we have to think, and social norms are important, but which social norms is important? And what's important here is really marriage norms and female mobility or female seclusion norms. So these are maps that I had created in 1994 based on reading hundreds of ethnographies. In fact, everything that I could lay my hands on, and taken data from that. And sometimes village studies actually tell you where a woman marries, what is the distance that she's married, who she's married, what proportion, and so on. So if you look at the appendix of A Field of Unseen, all that information is there. So these maps, as you can see, is very striking. This is for South Asia. So you can see that wherever it's green, the greener it is, the better it is, that we know. Light green is somewhere in the middle. What's white? If you see village, what is village endogamy? It really means that you are allowed to marry within the village. And in North, and then close cousin, that is your close kin, which is you're allowed to marry cross cousins. So often we don't realize that even among Hindu communities, in the north, Hindus don't allow marriage anywhere near a close kin, and you cannot marry within the same village, the idea being you're related to everybody in the village, and in South India you're allowed to do that. The underlying premise is, of course, that if a family has property, they're not going to want to they want to keep it, and they're not going to allow anybody to have it. So the logic is, if the woman is married at a distance to strangers, then we lose it to another family. Whereas if she's married in the same village, she's married in the extended family, then they can control it. And this is a universal sort of idea, because remember in the UK you had primogeniture. You only gave to the oldest son, so that it would not fragment, it wouldn't go in multiple directions and so on. So these two are important here. And the third is the idea of female seclusion norms. Now female seclusion has two elements. We tend to think of them as veiling, and this is something which I also teach in my class, that veiling is not just Muslim veiling. Actually they have different patterns of veiling. Among Hindus, you don't veil in your birth village, and you veil in front of elders, but in your birth village you walk, and there's a different cultural norms among Muslim communities, but there's a lot of veiling in North India. But the most important is not veiling, it's the gender segregation of space. And that's much more of a universal idea. Think of classrooms that go back, even in Britain, like many decades ago, girls sitting here, boys sitting here, etc. It's the idea of segregation. Or maybe you've read Thomas Hardy's Far From the Madding Crowd. All of you read it? You remember when Bathsheba Aberdeen goes to the corn market for the first time. She decides she's going to be a single farmer. She's the first time a woman has gone into the corn exchange, and every eye is on her. Of course, at the centrifugal point of the novel. Yes.
Sorry, Bina. There are three colors? Maybe I have
Yes, there are three colors. No, your eyes are all right.
Okay, so the second one, which states are like...
These are in the middle. Those are Maharashtra, and there are tribal communities. So you have...
Okay.
So the darker ones, so you have...
Darker ones, yeah, I can clearly...
And then those are Madhya Pradesh tribal communities. Within tribal communities, it was much more, there is no seclusion of that kind.
And the northern states are...
the northern states, all the rest,
high.
Punjab, Haryana, Himachal,
Right.
you know, UP, also a bit of the west, Gujarat and so on. But Gujarat is mixed, as you can see. Okay. Yes, so,
that's
yeah.
45 to 85.
5 minutes. So reasons for denying women's claims. Now, in 60% of the cases, they were denied the direct co-partnery shares. And in many cases, what they said was that the father has died before the 2005 Hindu Succession Act came into effect. And that was often a reason. But there were other reasons also that, you know, which I'll come back to that, the other kinds of reasons. But what's interesting is the second part of this slide, that the Supreme Court of India, the top court, it had 4 different judgments between 2016 and 2020. So there is this case in 2016 which said daughters cannot claim direct co-partnery shares as the husband has died before the 2005, when it was ratified, 9/9/2005. The next one says that daughter's right by co-partnery is a birthright. So there's no relationship whether the father is alive or not. The moment the daughter is born, she has a claim. 2018, there's a third judgment which returns to the view that the father had to be alive for the daughter to claim the direct co-partnery right. And then 2020, there was a bigger 3-bench judge, three judges. Co-partnery right is a right by birth unrelated to the father being alive. The point I'm making is that so much of it is lost in interpretation. Now, to me, it's not rocket science that if you have a right by birth, you have a right by birth, right? The moment you're born, you have a right. And the same with the son. So it's not being disputed in the case of the son, but it's being disputed in the case of the daughter. So let's hope that the 2020 prevails and keeps, because you have these 4 different judgments. And this is the final thing, the bias in language. Now, we divided these into 4 categories. Those which had progressive views, that said, yes, women should have this right, it's gender equal, and so on. And then regressive views, you can have regressive views and regressive language. A regressive view can be, you know, she doesn't really need property, after all, the husband will look after her when she's married, her father looks after her. So this is a regressive view. Or that she's already got a dowry and so on. A regressive language is much worse, and I'll give you some examples. So as you can see, typically it was regressive languages and regressive view were by the counsels who were fighting the case, not surprisingly, but sometimes also by the judges. So here's an example, some examples. The Karnataka, this is a South India court. It says, no female whose husband or father is alive shall be entitled to demand a share impartition as against husband or father. Reason being that under Hindu law, she's expected to take care of, she's being expected to be taken care of till her marriage. And after her marriage, her husband will take care of it. So her interest is fully protected. Then you have the Punjab High Court, which denies the claim, which says it's a disgruntled daughter who is the one who has tied Rakhi. This is that you claim somebody is your brother, to her brother, and on the other hand, she's dragged him to litigation. And then there's a female judge, who's the worst of all, who says, take the case of a Hindu male or female owning a 2-room tenement left behind by Hindu interstate. It may not be feasible to be portioned. In that event, the son and his family will be thrown onto the streets. The daughter will coolly walk away with her share of a matrimonial home, causing great injustice to the son and rendering them homeless and shelterless. And she goes on. The sister demands her pound of flesh at an unacceptable price, forcing the brother to sell the dwelling house or its leasehold right or interest to see that the brother and his family are thrown out into the streets just to satisfy and go. Now this is regressive language, you will agree. And by the way, in 2023, there is a handbook which is brought out by the Supreme Court, which says don't use gender stereotypes, and it's quite progressive. You can say, Well, you may use stereotypes inadvertently because stereotypes have often internalized, ingrained in our thinking due to societal, cultural, and environmental conditioning. And even when judges reach legally correct outcomes, the use of reasoning or language that promotes gender stereotypes undermines the unique autonomy and dignity of individuals. And goes on to say words matter, that they shape narratives and influence societal attitudes. It's like you and me lecturing. We're very progressive, but nevertheless. So finally, what needs to be done? I think at one level one can argue that you need to increase legal awareness, and not just at the level that women know their rights or their families, but also among the lawyers. Because if the Supreme Court can come to 4 different judgments in interpretation, imagine how much more confusion there could arise at lower levels in the court. The second is that the village, what happens is that suppose a man dies and his property then has to be registered in the names of the claimants, the heirs. And if at that point he tells the daughter, look, it's not a good thing to claim your brother's share, and she'll sign away her share. So at that point, NGOs, there are NGOs who are acting in it, supporting the woman against family pressure to sign away her shares, provide legal aid and guidance. So there are all these things which NGOs are doing to a degree, but only to a degree is it successful. And then you can have mediation. They're now talking about women's courts, which will be not going to the actual full court, but special courts to help women. And then this is an open question that India in 1992-93 reserved 1/3 seats in village councils for women, and every 1/3 head of the village council was a woman. But if you actually look at in gender and green governance, I've looked at what are the issues they take up, but they rarely take up issues which you would see are particularly gender related. So they say we were elected by the general electorate, so we don't necessarily take up gender related issues. There are some examples in Andhra Pradesh where this is changing and they're trying to intervene. Also some courts, some panchayats have jural authority and others don't. So there's all of this. And finally, you can fall back on the market and the state. Don't forget that there are also sources of land and property, and the state can make direct transfers of small plots to poor women. There are some policies to do that. And then I've been arguing that the market is also a possibility. So in Andhra Pradesh, in the late 80s, what the government did was that it said that if women formed small groups, and especially if they were Dalit women, low caste women, then they would be given a loan cum subsidy, a 20-year partly grant and partly loan, which they could use to buy land jointly. And then in many cases they cultivated it jointly. And finally, this is the work I'm doing now, that we can also think of property in terms of access via group approach. So this is a figure from Kerala, where you have small numbers of 5 or 6 women coming together to lease in land as a group. And that figure, you'll see is startling, the 73,000 roof farms in Kerala. I won't go into any details because that's the subject of my ongoing book, but basically that we have to think of more collective ways in the way we think of access to property. In a way, we create the commons. That doesn't mean we all have to jointly own it. We can have individual rights, but we can bring it together in a variety of ways for its use. And we could even think of that in terms of housing. I mean, imagine that domestic violence would be much less, more secure if women had an exit option in marriage. And what if, instead of giving her a large dowry, the father just said, here's a key to a bedsit, and and that could be your bargaining chip, if you like, or it could be an exit option. So this is it.